Let's take a look at a key case in tort law for occupiers liability. This case is Alexander versus Freshwater Properties, which was heard in 2012. The claimant in this case is Mrs. Alexander, and the defendant is a company called Freshwater Properties. The claimant suffered injury to her index finger when it became caught in the front door of the block of flats that she lived in. This block of flats was owned by Freshwater Properties. This injury resulted in partial amputation to her finger. The occupiers had employed an independent contractor to refurbish the door handles. However, the independent contractor left the refurbishment incomplete for a number of weeks. This, combined with the ineffective self-closing mechanism, which was known to the landlords, caused the door to pose a danger. The defendant occupier was found liable and ordered to pay the claimant compensation. This is because under Section 2, subsection 2 of the Occupiers Liability Act 1957, it states that the common duty of care is to see that the visitor will be reasonably safe in using the premises for the purposes for which he is invited or permitted by the occupier to be there. This had not been fulfilled by Alexander Properties, as they knew the work of the independent contractor was faulty. However, the independent contractor was also found liable as their work was faulty and they had left the refurbishment incomplete for a number of weeks. In an exam scenario, you would need to look at the facts and decide if the occupier had kept the visitor reasonably safe for the purpose that they are there. Leaving something faulty when the occupiers know that it is faulty is a good example of when a visitor is not kept reasonably safe.